I'm very sure you've been hearing the term PMLA very often, Prevention of Money Laundering Act, that has seen political opponents lock in a fierce battlefield this Lok Sabha elections. You have a sitting Chief Minister Arvind Kejriwal who has been arrested under this. He's of course out on interim bail currently, campaigning on a political rhetoric around his arrest. And then you have Hemant Soren, former Chief Minister of Jharkhand, who is in jail even now, with no relief with respect to the numerous bail petitions. There are others, like Punjab's former Forest Minister Sadhu Singh Dharamsot, arrested by the Enforcement Directorate in connection with a money laundering case. And then you have others like TMC leader Sheikh Shahjahan linked to Sandesh Khali horror, Manish Sisodia and Sanjay Singh, among others, who have been arrested. These are just few names that I have mentioned to put things in perspective for you to understand all of that. I have not brought in all the names, say over the last 1 year or even 5 years for that matter. One thing common between the two, Arvind Kejriwal and Hemant Soren, both of them skipped 9 summons from the Enforcement Directorate before being arrested. But why are we discussing this now? Supreme Court made a series of observations that is being seen as landmark by many. Essentially, experts say this is curtailing the powers of Enforcement Directorate against arrest or central probe agencies against arrest under the PMLA. The Central Probe Agency Enforcement Directorate cannot arrest an accused on the basis of material in possession, even if found guilty, is given in written under the Prevention of Money Laundering Act, once a special court has taken cognizance of the complaint of money laundering. Another very important aspect, an accused who is not arrested by the Enforcement Directorate during money laundering probe but appears before the special court following the summons issued by a PMLA court does not need to satisfy the stringent twin test for bail. This is crucial. The onus is not on the accused because, according to the court, he has produced himself before the court and isn't arrested. What is the twin test for the bail? The twin conditions state that when an accused in a money laundering case applies for bail, the court has to first allow the public prosecutor to be heard, and only when it is satisfied that the accused is not guilty and unlikely to commit a similar offence when released, can bail be granted. It makes the getting of bail in such cases extremely hard. A bench of Justices Abhay S. Oka and Ujjwal Bhuya have stated that in such a case where accused appears before the court after summons, the ED will have to apply to the concerned court to get the custody of the accused. This is being seen as clipping the right of the Enforcement Directorate against an outright arrest. This is largely being seen as protection against what many are saying arbitrary arrests. Remember, PMLA is right at the center of political battle, as I mentioned. Congress has claimed if voted to power, it will end weaponization of laws, seizures, arrests, arbitrary searches. In fact, P. Chidambaram himself has gone on record to say that if they come back to power, they'll do away with the current and bring out a different legislation, a newer legislation. CPIM in its manifesto has claimed that it stands for scrapping of draconian laws like UAPA and PMLA. The PMLA, in fact, just to give you a sense of what the history has been, very briefly, the PMLA was introduced in the Lok Sabha by the Atal Bihari Vajpayee government in 1998, and as Yashwant Sinha introduced it, it was opposed by several leaders. The law, though, was notified under the UPA government, the teeth being sharpened with amendments in 2009 and 2012. In fact, it's these amendments that eventually became a big hindrance for bail, whether it be in Chhagan Bhujbal's case or even in Sanjay Singh's case. We'll get to that, but far better than me to explain all of these, the contexts, the current ramifications, all of this, political and beyond. I've got with me an expert panel, Abhishek Sudhir, who's a lawyer and political analyst, Ashwani Kumar Dubey, a senior advocate, Apurva Agarwal, who's a senior lawyer, as well as Anurag Naidu, who's a political analyst. Thank you very much, all four of you, for joining us. There is one rule that I'm going to put out at the outset. This cannot get technical. This has to be in a way that each one of us, citizens of India, can really make sense of, to the context of what they are seeing around them and to what they need to know. The maximum legality that could have been done is what I have done. You all are experts and you have to break this down for us. Thank you very much again, all four of you, for joining us. Well, let me just take this question first to Apurva Agarwal. What do you make out of what the court has said today? How landmark is this? How critical, how important is this, if it is?
Okay, today's judgment is, we have to read it in light of the context of Mr. Arvind Kejriwal's arrest and his interim relief, which has been granted a few days back. Now, the critical part is, once arrested, getting bail was next to impossible. Now, that has been made a lot more simpler. And in fact, getting arrested under the ED Act has also been made a little bit more difficult. I wouldn't say it wasn't there earlier, but it's been made more difficult. Now, a special court where the ED cases are tried or money laundering cases are tried have to take cognizance of the offense, and the ED authority has to apply to the court to get custody of the person who's accused and or wanted to be arrested. Only if the court is satisfied that by the person will be arrested and invocation will be successful, then only the arrest may be granted, and in no other case. So in fact, it's getting it a little bit more difficult for the ED to ad hocly arrest any person without any material on hand. That's my take on the judgment today.
No, that's very interesting. So are you saying if this was there earlier, a few months ago, political leaders who have been arrested, it would have been harder to arrest them in comparison to the way they were arrested by the ED? Is that what you're trying to say?
It would have been more difficult to arrest them than what has been arrested right now. In fact, if you see the pattern which has been emerging right now, ED has been arresting people on grounds that they have material and the accused has been laundering money. Whether the material is fictitious or straight, it's a debatable question because the perspective will change from person to person and from which perspective you look at. So right now we are trying to get in a neutral party or an eminent judge or a court to decide that fact. And that will obviously lead to transparency, and also natural justice would seem to have been done. So in a way, it's a step in the right direction. In fact, our current CJI Chandrachud has also been very translucent about this and been advocating a more transparent and fair system on the grounds of natural justice. In fact, he has gone on record and stated that why have the political parties or politicians being arrested just before the election? So that obviously seems to be the right thing to do.
That's interesting. That's a very interesting thing that you're saying at this point. In fact, directly linking this verdict to high-profile arrests that have happened, including Arvind Kejriwal's recently. But if I can come to you, Ashwani Kumar Dubey, do you also read it in the similar line?
No, I have 2 points to say here. One, the ED and its officers are powerless to exercise powers to arrest the person shown as accused in the complaint if the matter is before the court and court has taken cognizance of it. Why this judgment has been passed?
Absolutely.
One, to protect the fundamental rights of the citizens. Two, to protect the citizens of this country from the unnecessary arrest. There is a section, since you have restricted us to speak in a plain and simple language, which can be understood by the public at large. There is a section 19 of PMLA Act, which allows the Enforcement Directorate officers to arrest any individual on the basis of material in possession of the Enforcement Directorate. I did not use the word court. in the possession of the Enforcement Directorate, and there is a reason to believe. Reason to believe means the Enforcement Directorate's reason to believe, not the court's reason to believe, in writing that this person is guilty. Meaning thereby, the courts, even otherwise if the matter is pending before the court has taken cognizance of a matter, court is hearing that matter. In that situation, if it appears that this gentleman has to be arrested, ED can arrest. But here, now the today's judgment is significant for two grounds. One, court says that once the court is, Honorable Supreme Court says, once the special court has already taken a cognizance, is dealing with the matter, and person appears pursuant to the summons, then you cannot arrest. This is one, which has protected the fundamental rights of the citizens. Two, so for the twin conditions which you referred in your opening remarks, those twin conditions still exist. One, that there is no person accused of offense under section PMLA shall be released on the bail unless the public prosecutor has been given an opportunity to oppose the application for such release. And two, where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds of believing, and that is why Sanjay Singh got the bail when court said, look, either you exercise the powers under section 45 or you give your consent, and Sanjay Singh was out. And third, the important question is that long incarceration of any person in the name of the law, long undergoing investigation under the pretext of a special statute, is the violation of fundamental rights of the citizen.
30 seconds, sir.
Courts in three judgments, Vijay Madan Lal Chaudhary, Justice Khanwilkar's judgment, Justice Sanjay Kumar's judgment, the ground to relieve, the ground of arrest must be informed. And third, today's judgment that if the court is dealing with the matter, you will not arrest. So all three judgments significant so far as the citizens' rights and protection is concerned. Yes, over to you.
Okay. I think both Apurva Agarwal and Ashwani Kumar Dubey have brought in some very important perspectives. But let me just go across right now at this point to Abhishek Sudhir. And before I go to the other two panelists, let me just bring in another perspective. If you look at the probes or the probes under PMLA Act, UPA vis-a-vis the NDA, what are we looking at? And if we can have those graphics up. So according to the data that we have got, or we have been able to research, between 2004 and 2014, that's under the UPA, you had almost 1,797 cases probed under PMLA. But under the NDA, it's 5,155. It's almost a 5 times higher number. UPA charge sheets were 102. NDA charge sheets 1,281. Similarly, if you look at the proportion, large difference for that matter. UPA tenure, if you look at the percentage of charge sheets, 6%. NDA tenure, 25%. Convictions, UPA, 0. NDA, 36 cases. Well, let me come to you, Abhishek Sudhir, at this point. With what the court has said today, plus if you look at the track record of what's unfolded under the UPA vis-a-vis what's happened under the NDA, how do you really look at this?
Well, Sneha, we need to go back to fundamentals, right? And the fundamentals are contained in the Constitution of India. Keep it simple for your viewers. Article 21 of the Constitution says no person shall be deprived of his life or liberty except according to procedure established by law, right? If you're deprived of your liberty, that is what happens when you're arrested, you're deprived of your liberty. That deprivation must be in accordance with the procedure established by law, and that procedure established by law must be just, it must be fair, and it must be reasonable. It's not enough to say, oh, well, this is what the law says, like in the PMLA, right? For example, the Constitution has certain safeguards. Article 22 states that when you are arrested, right, this is a general rule in the Constitution of India. When you're arrested, you must be informed of your grounds of arrest. Now, let's look at the NewsClick case, because that's a perfect illustration of the misuse of the PMLA. What happened in the case of Prabir Purkayastha? He was arrested, and at 6:30 in the morning, he is produced before a judge. And remand, right, was granted. He was sent to custody. His lawyer had to attend the proceedings by a telephone call because he was not informed. This in law, Sneha, is known as a violation of the principles of natural justice. Some of the principles of natural justice are you have the right to be heard. by a free, impartial judge, for example, right? Prabir Purkayastha was not heard. Furthermore, the PMLA states that when you're arrested, you must be informed of your grounds of arrest. Prabir Purkayastha was not informed of the grounds of arrest. What is happening, Sneha, in this country is PMLA is operating like an anti-terror legislation. PMLA and UAPA and its previous incarnations like TADA and POTA, you'll probably remember going back a couple of decades. PMLA has become a legislation to terrorize the citizens of India. And the stringent requirements are finally, I'm happy to say, being watered down by the Supreme Court in accordance with the mandates of Article 21 and Article 22. The grant of bail is virtually impossible in the PMLA. And Sneha, the problem with our Indian justice system, our criminal justice system, is the long, long wait between being arrested and the commencement of the trial. They say you are innocent until proven guilty. Let's take the case of Manish Sisodia, arrested February 26, 2023, Sneha. He has not been granted bail as of May 16, 2024. His trial is nowhere close to commencing. For example, you have situations where it takes 5-6 years for the trial to commence. This is a complete violation of Article 21. The procedure established by law is unjust, unfair, and unreasonable. The Supreme Court is finally fixing the PMLA, and I would say the ruling dispensation by getting the Enforcement Directorate to arrest Arvind Kejriwal have in fact unwittingly begun the end of the PMLA. You will find that the PMLA in the coming decade or so, my prediction is that it will be declared unconstitutional by the Supreme Court of India. It deprives the citizens of liberty. And look at
That's a huge statement to
Yes,
say.
of course it
That's
will
a
be.
huge statement to say because
Look at the data, Sneha. Look at the data. The data in
Supreme
terms of...
Court has been hearing cases after cases after cases. It can't suddenly come down one day, and it's all.
Look,
Of course, we must
TADA,
remember
as far as
that it's
TADA,
also been passed in the parliament.
You have to remember, so was TADA, so was POTA. Both were declared unconstitutional. The arrest of Arvind Kejriwal has begun is the beginning of the end of the PMLA. Sneha, you look at the electoral bonds. Every businessman, every business house is being harassed by the ruling dispensation for funds. You don't give funds, what do? They put a PMLA case against you. And then you want to get the ED off your back,
Okay.
so you make electoral bond donations. This is
Okay.
a complete scam, Sneha. It is a circumvention of our provisions. It is a sabotage of the Constitution of India.
All right.
Electoral bonds, PMLA, Enforcement Directorate, CBI, ruling dispensation,
All right.
DJP,
Okay.
they're all interconnected.
Okay, I believe Ashwani wants to make a point, but Mr. Ashwani, allow me to go across to another panelist who's been waiting for us, and that's Anurag Naidu. Anurag, you've heard what Abhishek Sudhir has spoken. How do you look at this, considering the arguments that Abhishek has spoken are very strong? He's saying this marks the end, the beginning of the end of PMLA. Very, very strong allegations under which several leaders are either in the jail or are charged or are out on bail or have been convicted.
I have a very different perspective, Sneha, having heard all the three legal experts on the panel. And, under the facade of Article 21, liberty, not everything, you cannot bring everything. You cannot say everything just because, you have some procedures, you have two agencies involved. The judgment that is rolled out, the judgment that is pronounced today, for me personally, how it appears is that you have a functioning agency in the form of ED. And now essentially what the judgment is trying to say, in my understanding, is that you have to go to the court to prove your ground for the arrest. And only if the court permits, based on the material evidences, you can go ahead and arrest. So by that time, and also not to forget, the majority of the cases that we are discussing, Sneha, on the panel today and other channels, is only the political cases, right? So PMLA does not only apply to politicians, it also covers other people, right? But political cases, there is a very high possibility and probability that they might influence the victims, or they might influence the evidences, they might tamper the evidences, they might,
Also,
how
correct me,
politicians
just one
work.
thing. I mean, continue with your answer, but one thing. Correct me if I'm wrong. Was it in 2009 that ED or the probe agency ED particularly got the teeth to be able to take cases against political leaders as well?
Absolutely. And also, not to forget, it is not a BJP versus Congress thing, Sneha. At least BJP had, charge sheets filed. BJP had convictions, right? Now, Congress is the one who enacted it to pass this particular bill. And 2009 was the first step when they started tightening it, right? So it is not typically BJP versus Congress, and also let's not try to make it that everything that ED is doing is wrong. I mean, if everything that ED was doing was wrong, they would Come on, why would we have 5,155 cases without any, evidence or without any substantial evidences? So, if we are trying to put a pressure and trying to downplay the influence of ED, I think we are probably hitting hammer on our own toes. We need to understand what kind of an influence today unaccounted cash has on our electoral system, what kind of an influence unaccounted amount has on our elections and political system. To control that, if we don't tighten ED, if we don't tighten
Nothing better to
PMLA, I
understand
don't
than
think
that
we're moving in the right
electoral
direction.
bonds, for that matter. That could be just a very good measure to try and gauge that, because otherwise we don't really have a measurement or a sense of how to
No,
really
you can
look at
tighten that.
that
No,
as
see,
well.
electoral bond,
You may
but
argue that that
electoral
was a
bond,
way to legalize it, but
Sneha,
that's the only sense that
electoral
we
bonds
can
are
get.
wide. Electoral bonds has got a legal standing. These are not amount in cash, right? Electoral bond is not somebody written in a pauthi and you have gotten access to the pauthi
Okay,
that some money
all
is
right.
transacted. It is through a nationalized bank. So it is all, I mean, what is wrong with electoral bonds? That's okay. I mean, you have your own, I mean, people might allege, yeah, there have been companies that have been involved in the cases and the next day they have donated. These are the questions BJP or the government of the day needs to answer. But that does not mean we completely scrap the whole system.
Okay, 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 okay. Abhishek?
Yeah.
30 seconds, 40 seconds, because
Yes.
Ashwini has been waiting. Go ahead.
See, my point is this: the money is not white. When you raid a company and say they've been laundering money, and then tell them, well, take your laundered money and donate to us via electoral bonds, what are you doing? Basically, you're allowing them to launder money through the electoral bond scheme. The electoral bond scheme was nothing but a money laundering scheme. Money laundering is a serious issue, Sneha. GPay, for example, UPI transactions. You're finding money laundering now has become so easy because of UPI, for example. There are serious cases for the ED to probe. But what happens? The ED is operating like a hafta agency. Raid a company, say donate to us, otherwise we will file a charge sheet against you, we will arrest you. That's what happened in the case of Pankaj Bansal. Pankaj Bansal was the head of M3M Builders. The Pankaj Bansal case was where the Supreme Court laid out a precedent that you must submit the grounds of arrest. And Sneha, I return to this last point that we have to fix our broken criminal justice system, right?
Okay.
This is beyond parties.
Okay.
Between arrest and trial, the wait is for years, and that is the true problem.
Ashwani Kumar, as well as Apurva, thank you for your patience. Ashwani Kumar, to you first before I go to Mr. Apurva Agarwal. Ashwani Kumar, my question to you is this. While Abhishek Sudhir may be arguing what he's arguing, the others would be saying, listen, this whole politics of you scratch my back, I'll scratch your back seems to come to an end now, with at least one political party cracking the whip. The opposition saying this is not the right way to see it. Legally, has the court now taken a stand that, listen, there seems to be a series of arbitrary arrests, or there seems to be a scope of arbitrary arrests that now needs to be curtailed?
The courts have enforced the fundamental right of a citizen of life and liberty, but courts have not diluted any of the provisions of the Prevention of Money Laundering Act, Sneha, with full conviction, I'm saying. Number two, when an investigation is complete, charge sheet is submitted, there is no need for arrest. Custodial interrogation is not required, Sneha. You and any common citizen understand it. Third, Sneha, why PMLA was introduced? PMLA was India's global commitment, Vienna Convention, to combat the issue of economic offense like money laundering.
You may say that, but custodial... No, you may argue that common person like you and I may agree to that, but the fact remains there have been series of arguments within the court also that you can't file charge sheet after charge sheet, supplementary charge sheet, asking for custodies. This is not, I'm not saying this, journalists are not saying this, court has said this.
No, special statute when the evidences of different parts of the country, when there are a number of arrests has to take place, when there is an evidence which is either in the circumstantial evidences and to prevent and control an issue of money laundering from various parts of the country and across globe. The investigation you cannot confine in a time-bound manner, which is in the criminal jurisprudence Indian Penal Code. This is a special statute. Why? Because the CBI needs the state's permission and general permission and specific permission, and there was no specific legislation, which centralized legislation, which empowers any agency to conduct the investigation. Had it not been this act, the K. Kavita would not have been arrested. Had not been this act.
Okay.
The Vijay Nair had not been this act. The other people across, this operating from different parts of the country would not have been arrested. Not only this, Even if you remember Kashmir separatists, the foreign money, the funding, the terrorist funding which was coming in the country had not been this act, they would not be arrested. So it is sitting in the TV channel saying that since a political party and I belong to a political party and ideology is this and arrest is illegal. No, there is a need to prevent and control the issue of money laundering. Sneha, 1, 2, to confiscate or take into custody any property that is likely to derive from or has involvement in cases of money laundering. And 3, the appointing of adjudicating authority in appellate tribunal to make it obligatory. PFI, how would I have arrested? Was the UAPA was sufficient or the foreign money which was coming from outside? So I understand the courts have not diluted any of the provisions of the PMLA. Court have said this is an excellent act, but unnecessary arrest should not be there. Over to you.
All right. Apurva Agarwal, how do you look at what has been argued right now? And I also have to ask you two things. There's never fire without sparks. Now, if I say something like that, obviously there seems to be a problem with money laundering. Obviously, there seems to be something wrong. Now, if the court has to go on within the paraphernalia of money laundering and say that, listen, there seems to be another problem. While there needs to be a crackdown on money laundering, there's another problem. There seems to be arbitrary arrests happening. Could you explain to this constitutionally, how big of a challenge is this that the court now seems to be addressing, and does it end here? Is there more? Legally and constitutionally.
Okay, it's not just to take a step back, in criminal law, there's a saying which goes, you are innocent till proven guilty in most of the criminal law matters. However, exceptions are made to that fact. In the money law, in this act and the PMLA Act, you are guilty until proven innocent. So, the maximum changes. The rationale behind this is that it's very difficult to prove money laundering cases because of financial complexities involved. Therefore, the power to arrest and the power to take custody thing is for the benefit of the authorities to prevent further such action from happening. And even though the fundamental rights are there, Article 21, Article 22, Article 40, blah, 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 which have been quoted by a lot of my panelists around here, the Constitution also provides for restriction on those fundamental rights at the behest to prevent crimes and other stuff. So I don't think so that's bad in the eyes of law. Secondly, regarding the arbitrary arrest, frankly, if there's suspicion of money laundering happening and custody needs to be taken, it needs to be taken. How else are you going to gather evidence, and how else are you going to prove the fact that money laundering has happened? I mean, as an outsider, the layers of financial transactions happens to outdo the audit and the various, to hide the various transactions. I mean, I won't go into detail on electronic media right now, but so therefore, this is necessary and required. If you're talking about arbitrary arrest, let me just remind the panelists and the audience at large. Let's take, for example, Arvind Kejriwal case. 9 summons were issued to him. He did not appear in any one of those summons. And finally, he got arrested for lack of appearing before the appropriate authority. 9 summons you defy the court and you defy your ED authorities. Are you trying to kid me? So there are always two sides of the coin. It may look arbitrary, but necessarily it is not. You also brought up the various data. 5,025 cases have been filed with the ED till date. Let's
30 seconds,
forget
sir.
Under which regime how many cases have been filed. How many matters have actually been convicted? Less than 36. So your premier agency, the Enforcement Directorate, which is supposed to go into PMLA, does not have the bandwidth to prosecute the people, or doesn't want to prosecute the people. That leaves a hand mark. Or we don't have the right people to prosecute them or investigate the cases properly. Out of 5,000 odd cases, less than 35 cases, hard to prove. So, what are you talking about? Arbitrary arrest? lack of
Okay. No,
intent
you're
to
making
investigate
very
and
strong.
complete the
You're making some
process.
very valid, strong insights, Apurva Agarwal. Let me just go across to Abhishek Sudhir at this point. Abhishek, you have been wanting to speak something, but before you go on to that, let me also ask you, you brought in Prabir's case. Now, in Prabir's case, it was UAPA and PMLA. It was the twin combination, literally, and it was literally this argument before the court that he was not even informed. PMLA, UAPA, both seen extreme, draconian in certain ways, have two different requirements of the person being informed while being arrested. At least that's what's being said, argued before the court. While that is being said, the whole thing about getting bail, whether in PMLA or in UAPA, is so burdensome, is so cumbersome. Is it fair to say that you're seen as a criminal until proved innocent?
Yes, and that is what Mr. Agarwal says, and also he made a factual error. Article 21 is absolute. The restrictions he speaks of on fundamental rights are Article 19, the right to freedom. The right to freedom is restricted. But Article 21, no person shall be deprived of their right to life or liberty except according to procedure established by law, is an absolute statement of principle. There are no exceptions to it.
Okay.
The same with Article 22 and Clause 1. Shreya, tell me something. The 13-month gap between arresting the Deputy Chief Minister of Delhi and the Chief Minister of Delhi in the same case. Manish Sisodia has been languishing in jail for 13 months. Why do we have bail, Sneha? Why do we have bail? Because you're innocent until proven guilty. In India, it takes years for the trial to commence.
Okay.
Now, what happens to Prabir Purkayastha? Last 7 months, October 4th, Prabir Purkayastha was arrested and was remanded to custody. He is released and not yet, I think, has not yet been released. The Supreme Court has said he should be released because his arrest was illegal. He was not given the grounds for arrest and the remand also was illegal. Now, who is going to give Prabir Purkayastha 7 months of his life back? You have all sorts of allegations you've made against him, but sir, he is innocent until proven guilty.
Okay.
And the Supreme Court has granted financial compensation in the past, basically, where arrestees have lost months or years of their life in prison. Right, Sneha, if the Enforcement Directorate wants custodial interrogation, by all means do it. You want to file charge sheet after charge sheet, by all means do it. But don't oppose bail. If you're not able to start the trial in the so-called liquor scam, basically for 2 years you've not been able to commence the trial. When is the trial going to commence? The trial is not commencing. That's the problem. You're depriving people of their liberty. Right? Sanjay Singh was granted bail. Arvind Kejriwal was granted bail. Now Manish Sisodia has reapproached the court, so bail arguments have been heard, and I'm sure he'll also be granted bail. The general rule, Justice Krishna Iyer said, Sneha, was what? The rule is jail, not jail. The rule is bail, not jail. Bail, not jail. Procedure is the handmaiden of justice. You cannot discard procedure. If you discard procedure,
no.
the criminal
In
justice
fact,
system will collapse.
It was opposite. Under UAPA, if I'm correct,
Yeah.
what he has said is bail is an exception.
No, I'm talking about Justice Krishna Iyer's
I see.
old saying,
Okay. All
where he
right.
said
Okay.
the general rule in our criminal jurisprudence is bail, not jail. As Mr. Agarwal said, right, that innocent until proven guilty. That has been turned on its head. The PMLA, UAPA is guilty until proven innocent. You're turning criminal jurisprudence on its head, and we have the slowest criminal justice system in the world. It takes 20 years for a case to come to some sort of conclusion. Look at the number of cases from the 1980s and 90s that are still being litigated. Appeal after appeal, tariq pe tariq. I mean, it has to end. So then you either fix your criminal justice system and deny bail, or if you can't fix your criminal justice system, you can't start trials on time, then grant bail. Then let the accused furnish an undertaking under Section 88 CRPC. That is what the Supreme Court has said today. They've said you can't keep arresting, filing charge sheet and not commencing the trial. Commence the trial. When will you commence the trial? Justice Sanjeev Khanna and Dipankar Datta have said that in the case of Manish Sisodia, if they don't commence the trial in 6 months, you come back to us, and Sisodia has gone back to them.
All right, Anurag Naidu, we're totally out of time. My last question to you. When you look at what's unfolded in the Supreme Court, in the middle of a heated election campaign, the mother of all elections as we call it, in India, do you see that either of the political parties can't really make a political rhetoric out of what the court has said today just because both have equal to blame?
Yeah, maybe not the leading political parties, but some of the regional political parties will try to make a rhetoric out of it, particularly the BRS and other small NCP and other parties which are, which are crying fault. But one important thing, Sneha, that I want to pick up, when we are mentioning about arbitrary arrest, before we label all of this 5,000 odd arrests as arbitrary arrests, we should have the data. How many of them have been proven to be having arbitrary arrests? Now, Abhishek mentioned about, now look at, I don't understand his logic. He has been mentioning about there is a delay in the legal
Is that
system.
even possible?
Right? Now, what makes him think?
Fascinating point you've brought in. It's a fascinating point. Anurag,
Let me make one point.
Just a minute. It's a fascinating point you've made. Explain to us if that is even possible. Yeah, please go ahead.
3%.
No, allow Anurag to speak. It's a fascinating point, sure.
Just 1 second. When Abhishek mentioned, with so much of passion, that the whole legal system is about delay, tariq pe tariq, tariq pe tariq. What makes him think that if ED is asked to go to the court for, getting a permission to arrest, it is going to be any faster? It is not going to be delayed. Now, in that way, the legal system is going to be faster if saying, "हाँ भाई, कल जाके आप arrest कर लो, कल दे देंगे decision, तारीख नहीं देंगे." Can you guarantee? You can't guarantee. Yeah, you can never guarantee in this case. Also, we have to understand. Previously mentioned in his point that this electoral bond scheme. What makes you think that because again, this PMLA is not diluted today. There's just been a procedural changes. It is a change in modus operandi. What makes you think by today's judgment of Supreme Court, by enforcing that or by accepting that, you are going to completely change the scenario of electoral bond? Do you have any evidence? Can you make me understand and prove to me that you are not going to have this kind of electoral bonds going further? Please help me understand.
Okay. All right. I know, Abhishek, you want to make your point. I'm totally out of time. Maybe I can just...
10 seconds. Yeah.
Okay, less than 10 seconds.
Look, the electoral bond scheme, if the Bharatiya Janata Party had been transparent from the beginning and said we will not hide the list of donors, then the scheme would have never been struck down as unconstitutional. The scheme was struck down as unconstitutional because you kept the donors anonymous, and the Supreme Court said that is violative of the Constitution.
This argument can go on forever. The counter to this can also go on ever. But as on this show, every time we have just one promise for all of our viewers. There will never be only one view that will be shown. There will be never one side that will be taken. It's our duty to ensure you are equipped with all perspectives, all sides for you to make your decision. Thank you very much, Abhishek Sudhir, Ashwani Kumar, Apurva Agarwal and Anurag Naidu for making this very engaging, informative discourse a reality. Thank you very much. It's time for a very short break. On the other side, we'll bring you all the big happenings of the day.